very much, Your Honor. So as I indicated, I want to talk a bit more about the travel time issue for San Francisco to Los Angeles. I also want to come back for just a second to the financial viability issue. And counsel for defendants has pointed saying we have lots and lots of studies. There are lots of studies, and we're entitled to rely on our experts, and therefore we win. Well, it depends, because of course studies can say lots of different things, and in order for an agency to rely on a study, the study has to be about what the agency is determining. You can't look at a study on water use if you're asking about air quality. You need to look at a study of air quality. And when they are looking at the ridership on the iOS South, they need a study that looks at ridership on the iOS South. And that study needs to be based on substantial evidence. And because, again, even an expert opinion is only valid, is only substantial evidence when it's based itself on evidence or on facts that it can rely upon. And the problem is that the only analysis they've got of ridership on the iOS South is based on a ridership model that came out of data generated for the full Phase 1 system. There is no evidence anywhere in the record that you could use to determine what's the ridership for iOS South, where you're asking, okay, how many people are going to actually ride on iOS South? Because all they had was what's called stated preference surveys, which is they go up to people and they ask them, if we gave you a choice of this or that, which would you like? Which would you do? So they might say, if we gave you a choice of going by auto between San Francisco and Los Angeles, taking 5.5 hours and costing $110, or we gave you a choice of taking high-speed rail between San Francisco and Los Angeles, and it's going to take 2 hours and 30 minutes, or 3 hours, let's say, because they're talking real world, not something fantasy. It's going to take 3 hours, and it's going to cost you $110. Which would you choose? So that's the type of choice they gave. But they never asked, well, if we gave you a choice of traveling by car between San Francisco and Los Angeles, or taking a bus from Los Angeles to Burbank, and then getting on a train in Burbank, and taking that train to Merced, and then getting off of Merced and getting on another bus to go to San Francisco, which the whole combination is going to take you 6.5 hours, and it's going to cost you $125. They never asked that. They never asked anything about that type of a system. And consequently, any ridership figures they've got are fantasy. They are not based on any substantial evidence. So that's the problem we have with that part of the financial viability is that it includes an analysis of ridership that is totally invalid and has no basis in substantial evidence. Now, I want to now go on to the issue of
Before you do that, let me give Ms. O'Grady a chance to respond if she wishes to on that issue.
Your Honor, the record contains substantial evidence that support the ridership figures that have been reviewed by the ridership technical advisory panel and reviewed by the GAO, and the authority stands behind it.
Just one further thing about that, which is, yes, in fact, the ridership peer review panel did, in fact, look at the ridership model for San Francisco to Los Angeles. The ridership peer review panel never looked at ridership on the iOS, nor did the GAO. Nobody has given a peer review of the ridership on the iOS stuff. There is simply nothing in the record that says somebody looked at this and says it's okay. It's just the ridership. It's just their consultants using the data they got from the San Francisco, Los Angeles, and extrapolating from that based on data that wasn't obtained for the iOS South, and saying, well, this is what the ridership on iOS South will be. It's apples and oranges.
Any further?
Your Honor, the authority, all they're doing is disagreeing with the authority's expert, and that's not a basis for overturning the authority's judgment.
Let's move on to the next issue.
Yes, Your Honor. So I wanted to move on to the issue about the San Francisco-Los Angeles travel time. And this is the graph that was in the Vaca memo, as it's called, which was the authorities' analysis of going from San Francisco to Los Angeles. And this one is showing, this one I believe is starting in Los Angeles and moving north to San Francisco. So this is, and this is the altitude. So this is showing the going up the Hatchbees and then back down the Hatchbees. This is the Central Valley area, and this is the Bay Area here. One of the things I want to point out to you is if you look at the part of it that's in the Bay Area, which is from here to here, that you'll notice that here's the line for 150 miles an hour, here's the line for 100 miles an hour. The line showing that this is what the speed they're doing, I'm sorry, this is 150, this is 100. The line showing the speed they're maintaining, 125, not 110. So they're using 125 miles an hour to get this time from LA to San Francisco and San Francisco to LA, not 110, which is what was called for in the, basically in the approved plans. That in itself makes it a problem. But in addition to that, if you look at this section here, so here's where they're going down with the Hatchbees, and it's fairly steep, 220 miles an hour. And if you read the memo, what Vaca says in the memo is, well, we are assuming we'll have better braking systems that will allow us to go 220 miles an hour down these slopes. But if that's not the case, then we'll just have to lower the speed to 150 miles an hour, and that will add another 3 or 4 minutes. So they admit, essentially, that this is sorry about that. They admit that this is something that's fantasy land, and they have to add more time there. The next slide shows in the other direction. Again, we've got the same problem. This is starting in San Francisco and going down to LA, and again, this time you're going down here. It's even steeper, 220 miles an hour. And if you look in this whole area of the Central Valley, straight 220 miles an hour, right through Fresno, right through Bakersfield, right through all of the cities in the Central Valley. And there's a problem with that. This is a slide, a cover slide from a presentation that High Speed Rail Authority gave to the Industry Forum in Fresno in September in 1911. And they showed this slide. And that slide says the operating speeds are up to 220 miles per hour. They are 90 to 120 miles per hour in urban areas. So here's the map. Right down here it says urban areas. And there are all of these areas that are urban areas. That's, let's see, there's Palmdale, there's Bakersfield, there's Fresno. They're all yellow urban areas. And by rights, it should be applying this 90 to 125 miles an hour because that's what they promised. They said 90 to 125 miles an hour in urban areas. But if you look at the previous slide, you can see that it's 220 is what they're saying. That's basically they have submitted this into public, including the French Central Valley, saying we're doing 125 miles an hour top in urban areas. And you can ask, well, maybe those maps aren't accurate because the authority has argued, oh, well, you're using these Caltrans measurements. Well, we use the Caltrans database basically because that was the most accurate representation of what's actually U.S. Census Bureau data on the extent of urban areas. And it was easy to use on Caltrans using Google Earth, but we could just as easily measure it off of these maps, which are in the authority's record. These are from the EIRs, and they also show these. Now, admittedly, frankly, the ones we used are more accurate. This is the best one we could find. This is from the Bay Area to Central Valley EIR, and again, you can see here's the urban area for Fresno, and you can see it's there, and you can see it's labeled urban area. So we could have measured it off of this, but it wouldn't have been very accurate. We felt we were better off using a more accurate measurement. But the data is right there in their data, in their record, the fact that these are urban areas. When you take all of them together, you end up with a time of more than 3 hours. That's not 2 hours and 40 minutes. It's not even close. And it doesn't matter what route they go through the hatch piece on, they still got that same elevation to deal with, they still got those same slopes to deal with, they're still going to have to reduce the speed in the hatch piece regardless of how, unless they were going to actually start on one side of the hatch piece and drill a, I don't know, maybe 80-mile, 90-mile tunnel right through the middle of all of these earthquake faults, which nobody has talked about doing. For one thing, you wouldn't be able to get Palmdale if you did that, you'd be down into the ground when you went through Palmdale. So they've got to, if they're going through the route they've chosen, which is going through Bakersfield, going through Palmdale, and then down to Burbank, they've got to go with a hatch piece. It is going to slow them down. They can't make any better. They can't possibly make the 2 hours and 40 minutes, regardless of which alignment. Now, they could choose another alignment. They could choose an alignment that doesn't go through Palmdale, doesn't go through Bakersfield. They could choose an alignment that went straight from LA to San Francisco along I-5, and there'd be no problem. But that's not the alignment they've chosen. And if they want to do that, they have to go back up quite a bit to do that. But right now, the system they're choosing simply cannot meet the 2 hour and 40-minute requirement.
Your Honor, there is not even a C plan for the hatch piece. The PowerPoint is a very high-level presentation. The actual plans and the environmental documents show what the actual speeds are for the train, but there is substantial evidence that supports in the record the authority's travel time calculations. All they're doing is disagreeing with the authority's experts.
Well, I think he's doing more than disagreeing with the experts. I think what Mr. Clashman is also doing is highlighting certain assumptions that the expert relied upon in reaching his conclusions, and pointing out that those assumptions do not result in those conclusions. He's talking, for example, about speed up and down at the hatch speed, and he's talking about speeds through urban areas, and the assumptions that were essentially utilized for those particular conditions seem to be inconsistent with the conclusions reached by the expert.
The authority has never he really is disagreeing with the experts. The experts, he has decided that on the basis of PowerPoint, the authority is going to slow down on its nonstop through, I don't know how many cities he thinks in the valley, but that is not what the experts have calculated, and that's not what the authority intends to do. All he's doing really is second-guessing the experts, and the authority has calculated the downward speed. They presented that to the peer review group, who accepted it and reported on it to the legislature. All this is speculating and second-guessing what the authority's experts have done.
All right, I understand. Other issues you wanted to raise, Mr. Clashman?
The only other thing I wanted to just bring up is just really generally what this case is about, which is basically the legislature put a ballot measure on the ballot for the voters and basically asked the voters to approve a project, high-speed rail project for California. And they knew it was going to be a hard sell. And as the Court of Appeal noted, one of the things they did to try and get that sale through was they put in the authority in a financial straitjacket. They put in the requirements in 2704.08C and the requirements in 2704.08D that are intended to make it hard for the authority to get access to the funds. And they did that. No, I mean, why would they do that? Why would they make it hard for the authority to use the funds that the voters approved? Because they knew if they didn't make it hard, if they didn't give the voters some assurance that we're not just building a boondoggle here, this is going to be something that really will work, the voters wouldn't have voted for it. And so they put in the requirements in 2704.04A, and they put in the requirements in 2704.09 also to convince the voters you're not buying a pig in a poke. You're buying a system that is going to meet certain requirements, and you can trust us that it will meet those requirements. And the voters went ahead and approved that.
What if the legislature decided tomorrow to create a high-speed rail system. And they did it through their legislative authority. They sent the bills to the governor. The governor signed those bills. Would they be prescribed from implementing that as a result of Prop 1A?
The problem with Prop 1A and with the earlier establishment is those two measures, the Public Utilities Code sections and Prop 1A, essentially gave the High-Speed Rail Authority the exclusive right to do a high-speed rail system in California. So if they were going to do something different, make another public agency that was going to do a different high-speed rail system, they would have to repeal that.
What if they didn't do that? What if the legislature simply determined that, in fact, it's going to give the High-Speed Rail Authority and funding to build a high-speed rail system, and the governor signed a bill that allowed that?
That it's going to give, I'm sorry, that it's going to give a new agency?
Same agency.
Same agency.
You just give it to them.
I think the
Would Prop 1A prescribe that?
I'm sorry?
Would Prop 1A prescribe that?
I would say yes. I would say that Prop 1A would say you can't do that because we've already said what type of system the High-Speed Rail Authority can build. It's got to be this type of system. You can't tell it, you can't give them free rein anymore to build anything they want. You've already locked in. And again, as O'Farrell said, the legislature has the ability, when it puts it on the ballot, to decide how stringent and how loose it wants to make the requirements. It can make the requirements as loose as it wants. It can make the requirements as tight as it wants. Once the voters approve them, it's stuck with whatever the voters approve. You can't change that anymore.
Ms. O'Grady, you want to respond to that question?
To this point, just very briefly, the Court of Appeal notes in their opinion the courts have been particularly attuned to the fluidity of the planning process for large public works. And in fact, the Supreme Court has allowed substantial deviation between preliminary plans submitted to the authority, to the voters, and the eventual final product.
I'm not going there. My question really has to do with the nature of Prop 1A and whether or not it's a prescriptive substantive act and a bond act, or primarily a bond act. And so what I was asking was whether or not the legislature could adopt new legislation for a high-speed rail network and give that authority to the High-Speed Rail Authority.
They could, or they could simply give appropriate money under the existing Rail Act, under the Public Utilities Code. But yes, that is the authorizing statute for the authority to create high-speed rail, and there would be nothing to prevent the legislature from appropriating funds directly.
All right. Other issues council wish to raise?
I guess the only thing is a very general concern I have, and it was somewhat of a concern with the prior part of this lawsuit in terms of what do the voters understand and how is it going to impact the voters if that understanding gets undermined. In the first part of it, the Court of Appeal basically said, well, you misunderstood what 2704.08 is about and the role of 2704.08C and 2704.08D, and basically said 2704.08D is the important part of that section, not C, and therefore your lawsuit is premature. Well, I don't know if the voters actually understood that or not, but apparently the Court of Appeal felt that's what the voters understood. Here, I think it's much more fundamental. In other words, the question is, what did the voters think they were doing when they approved Prop 1A? Did they think they were just providing bonds, and that was the only thing, and the legislature was free to change how those bonds could be used, depending on what it felt like at some future time? Again, could the legislature write a new act that would say, oh, you can go ahead and build something entirely different as long as you don't use the bond fund? I don't believe that's what the voters understood. If the court and your court and Florida's or the Court of Appeal now basically comes in and says, oh, you know what, that's okay. I worry about what that's going to do to the confidence of voters in what they approve. I wonder what it's going to do to California voters' willingness to vote for something that's put on the ballot, because they will lose their trust in what's on the ballot. They will say, oh, I don't trust it. They put things on the ballot and they do something different. Why should we trust them? I think that's what's really at issue here, is the trust of the voters.
Ms. O'Grady, any final comments?
Your Honor, I don't think anything that was presented in the Bond Act would lead the voters to think that the Bond Act was the sole governing system for high-speed rail. The voter pamphlet tells them what a yes vote means. It's really simple. A yes vote on this measure means the state could sell $9.95 billion in general obligation bonds to plan and partially fund the construction of a high-speed train system in California. That's what the voters approved. That's what's being built. Aside from that, I would just thank the court for its time and consideration. And we believe the plaintiffs have not shown that the authority has made any decision that precludes compliance with the Bond Act. The authority has shown its decisions are supported by the record, and plaintiffs' claims have proved meritless, and we ask the court to enter judgment in favor of respondents.
So, question as a plaintiff, I'll give you the last word if you want.
Sure. How can I pass that? Your Honor, again, we think that the plain language of the measure is where you have to start from, not what the legislative analyst said about the measure. And if plain language of the measure says that they shouldn't be doing what they're doing, then they shouldn't be doing it. But I do want to echo Ms. O'Grady's thanks for the amount of time and the efforts that this court's put into this. I have to say I really appreciate the court's thoughtfulness on this case and for that matter, the other cases on high-speed rail that I've had in front of this court. I've tremendously appreciated your involvement and your interest and your intellect on this. Thank you.
Thank you, Mr. Bennett.
Yes, sir.
Thank you all.